Hi everyone, and welcome to the Art of Estate Planning's monthly Facebook Live. I want to first acknowledge that I'm hosting the training from the lands of the Turrbal and Yagara people. I also acknowledge the traditional custodians of the lands on which each of you are living, learning and working from today. I pay my respects to elders past, present and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. Thank you for joining us. We're so lucky today to have the wonderful Laura Tatchell, who will be speaking to us about copyright afterlife. And I think this topic is going to be so relevant for people, and particularly relevant in the future, given the way that the landscape for copyright is changing and the sheer volume of intellectual property that is being generated. Laura has been kind enough to join us from sunny Perth. Laura is a principal at Tatchell Legal, where I believe it's her and her favourite father. I'm going to say favourite father. In case he's listening, make sure he's the favourite. But Laura is part of our estate planning community in our TT Precedents Club, a very valuable member. But I think the reason why Laura is the best person to speak about this topic, which I only recently found out, is that Laura is a specialist in intellectual property. She's absolutely nailed it. She is here to share her knowledge and always generous with her information. So please feel free to send us through questions. Let us know that you can hear us as well. So pop comments so that we make sure we've got some people listening. If you have any questions, send them through and we'll break in when it's the appropriate moment to ask Laura. But without further ado, Laura, I'll hand over to you.
Thanks so much, Carrie, and thank you to Tara and for the whole Art of Estate Planning crew for letting me speak to everyone today on a topic that I'm really passionate about. It's a real honour to be speaking to so many wise owls out there in the community who I always draw so much inspiration from week to week here in the community. So I've been a part of this community for about 3 years. To give you a little background on me, I was an intellectual property lawyer at a firm called Rays here in WA and then again in Melbourne for about 7 years before I had a few other little legal jaunts, and then have been in the wills and estates planning sort of scene for about 3 or 4 years now. So this topic, copyright afterlife, so what happens to our copyright assets from creators, inventors, from writers, from artists, all sorts of people, when they die, is something that I was really interested in because it obviously covers off on those two topics. So today's presentation, let me just click to the next slide. So it's obviously just general information only. So anything that you hear me saying before you go off and sort of spruik that to your clients, make sure you go to those sort of primary resources. Just a little rundown of what we'll be talking about today. So we'll be covering off on what exactly is copyright. We'll talk about sort of how we know that those rights are owned on death, who owns those rights. We'll talk about what happens when somebody has a will or if they don't have a will, and all the different ways that rights can be sort of transferred in different ways, whether it be to an individual or a trust, etc., and any issues that crop up, particularly with joint ownership. There's obviously the different roles here where we have an executor, maybe a trustee, and then the ultimate beneficiary, and the different rights that those individuals have. We'll talk about different licenses that could be in place that might need to be followed, the societies that collect royalties that are sometimes involved depending on what the copyright asset is. We'll also be talking about resale royalty rights, which are only relevant in relation to visual artists. So we'll talk about what that means and why that might be important for you. And then just do a little rundown of the tips and tricks that you might want to think about. So why might this be important to you guys? So oftentimes we're involved in advising clients on their estate plans, whether we're drafting their wills or maybe we're just advising as accountants and financial planners on the way that things will roll if somebody lost capacity, if they died. And oftentimes in this space, we don't have a bloody clue about what copyright is. We don't know about intellectual property. And sometimes our clients don't know that it's important. So they might not be the ones to be, bringing it up as a matter of, oh, and what about my copyright assets? It might be something that you need to delve deeper into. And hopefully today's presentation gives you some flags about when to think about this stuff and what to consider. So you might also be involved as an executor or advising an executor in this role, and maybe the estate has some copyright assets. So maybe it's a collection of paintings or writings or manuals. Maybe it's some source code to some software. Maybe it's some films, or what else could it be? So many different things. Musical recordings. Could be entire music catalogue. Maybe you've got a really famous musician as your client. So in that executor role, having a think about what things you'll need to think about is really important. So copyright is the bundle of rights that are given to the original author or creator of an original expression of information or ideas. So I think I said that in a roundabout way, but it is the expression of the idea or information rather than the idea or information itself. So often referred to as a work. There's 4 different types of works. We have literary works where we're talking about books, poetry, lyrics to a song. Maybe it's a letter or a manual or some source code. We have artistic works, so paintings, drawings, photography, sculptures, anything of that sort of ilk. Dramatic works are choreographies and plays. So there's the screenplay for a play. And we have musical works, which is like a musical composition for music. And then we have a bunch of other different types of copyright, including films. We have recordings, so that could be a podcast or a musical sound recording. We have rights that exist in broadcasts of different rights. And we also have rights that exist when something's published. So when an original work is created, there's a copyright that exists if it is an original work by an author. And then when it's published later, it's another type of copyright. And that gives further rights to potentially a different person for a different amount of time. So there's a bundle of rights that are given to the creator of these things. So you've got the right to publish the work. You've got the right to copy or reproduce the work. You might be able to, well, you will be able to communicate the work, whether you're communicating it on your Facebook page or on your website. You can broadcast the work. You can make an adaptation of the work. So, for example, we've seen screenplays being made into films or TV series. We've seen films being made into TV series. I don't know if anyone has watched the One Day movie that got adapted into a TV series recently, which was excellent in my view. You've got the right to sort of display the work. So maybe it's a sculpture that you're putting up in the town hall, or you are causing the work to be seen or heard. So maybe you're playing the music over the speakers in public, for example. So all of these rights are given usually to the creator of the work. So when we're talking about literary, artistic, dramatic, or musical works, it is the creator of the work that will own the rights in the first instance. But there are some little nuances to that, which we'll talk about. When it's a film, it's usually the producer, the one who's paying for everything to put it all together, that will own the rights. And then there's different rules depending on what sort of asset it is.
That's very interesting, Laura. I'll just give you a breath there. I'm a movie nerd, so knowing that it's the producer that owns things doesn't surprise me in many regards, given that's where the money's come from. With those bundle of rights, are they something under statute law, or are they under common law, or is it assumed, or is it something they have to seek?
So this is under federal legislation. So we've got the Copyright Act 1968, which is the legislation which covers off on copyright across Australia. And our rights kind of are very similar to rights across the world. So we have a convention called the Berne Convention, which a lot of countries are party to, which means that these copyright rights are protected almost globally.
Great.
There are another set of rights that kind of sit alongside copyright, and you might have heard of them before, but maybe not. They're called moral rights. And these rights are only given to the creator of the work, and they last for the duration of copyright. And they include the right to have your name attributed as the author of the work. You also have the right to not have someone else falsely attributed as the author of the work. So I don't want Carrie to be the author of my work because it's mine. And also there's a right of integrity. And the right of integrity is the right to prevent your work being treated in a derogatory manner. So a manner which would be prejudicial to your honour, to your reputation. Examples of this sort of thing would be, say, for example, I'm a writer and I've written some short stories and someone publishes my work in amongst a bunch of other Nazi authors, for example. This is misaligned with my values and this would be prejudicial to my reputation, for example. So that would be a breach of my moral rights. Another example would be if someone, graffitied all over your public work, your painting or your sculpture, and the way that the graffiti, made the work look was not in line with your honour, was not in line with your integrity as the author. So again, that would be a breach of your moral rights. These rights are also under the Copyright Act. They cannot be assigned and they cannot be sold. So when the author later dies, they can still be exercised by your executor or administrator if you did not have a will. So the executor can enforce those rights for you if you've then passed away, and any damages flowing will come into the estate. So that's just the relevant section of the Copyright Act.
That's the best explanation of moral rights I think I've heard, Laura, and but maybe by best I say simple because I got it. So thank you for sharing that.
No worries, pleasure. So they're not always enforced. I think they're not often known about in the right way for the artist or the creator. So, but definitely there, and definitely something to be aware of as an executor. So you've got a duty there to do that. Copyright usually lasts for the life of the creator plus 70 years. Now, it used to be 50 years, but Disney lobbied so hard because they wanted their rights to carry on for a further couple of decades, and they won. I think they're trying to lobby again to make it up to 90 years or so, and so far we haven't seen any change, but hold that thought because we can't just keep on going forever. But that means it doesn't just cease on the death of the creator. And there's different duration of copyright for other types of work. So broadcast the rights last for 50 years from the broadcast. And if you've got a published work, there's a further 25 years from the publication where those rights will exist. There's some different rights depending on if it's an orphan work. An orphan work is where we cannot find the creator. It's just not clear. So the question of does this client own the copyright once they've on their death is going to depend on a few things. So when they created the work, were they an employee? So under the Copyright Act, the employer will own anything created by an employee, which some of you might be aware of. So that means that that person doesn't have any rights. It's their employer that will own it. And the employer might be a company or it might be an individual, for example. But usually it's going to be the creator, but there's some nuances again in relation to sometimes with photography, if you're using it for your personal use and you've commissioned some photographs, then the person who's commissioned the photograph will own that. There's some issues that come up sometimes for people who might not be an employee. They might be a director who's just drawing funds from their company, that they're just drawing drawing income. And if they've created something, so say they've created the logo for the company, maybe they've created some engineering drawings or a manual for how things should be operated for the business, all sorts of things. They might just assume that the company will own that because, well, I'm doing it for the company, so they'll own that. But if they're not an employee, they will own that. And so that's an issue that can come up when we're thinking to enforce those rights, because if they want the company to own those rights, they need to do an assignment. So copyright can be assigned in writing to anybody, and this can be done by contract. It can also be done by will. Copyright is a personal right under the Copyright Act. And so, along the way, maybe someone created the work and then they entered into a publishing agreement or a recording contract, or they sold their business and they assigned all of the rights in their intellectual property to the new owners. So then they're not going to own it. The new entity is going to own it. So in other situations, the client might just own the shares in the company that owns the rights. So we're dealing with the shares in the company rather than the actual copyright. Sometimes copyright is owned by more than one person because a couple of people might have been involved in the creation. So in that instance, the ownership is joint, and joint ownership without anything further in writing means that each individual joint owner has to agree on any commercialization of the work. So they can't just each decide, oh, I'm going to license it off here, I'm going to do this. They need to all agree. They can't sell off their little piece of that copyright. They have to agree. So that can create deadlocks because it means that if we're not agreeing, then nothing can be done, which can be very difficult. So that's where sort of joint ownership can be really difficult, and it can bring up real issues, which we'll talk about how that kind of manifests in wills.
Laura, just before we go on, I've got a question here in relation to the timeframes. Christine has asked us, with those timeframes for published editions, so obviously we're talking about print copyright here, does the 25 years renew each time with a new edition when it's released, or is it only from the creation point?
I think there would be a new copyright attached to the new edition because each edition would be slightly different. So I think there would be a new, but I can confirm that if you want to sort of send that through to me.
Yeah, and I think someone sort of suggested that it's probably not because the criteria would be around, works of originality. So if the amendments are minor, it might not. But yeah, I think that's an interesting question and maybe not a straightforward answer because both, we're not sure about that question. But I think it shows how, when you're dealing with a client that has that sort of a valuable interest, it's not black and white.
No. This area of law is very complex. And there's different layers to the copyright. So, for example, for a song, you have the rights in the recording of the song. You have the rights in the lyrics. You have the rights in the musical composition underneath the song, so the score, for example. And then there might be, a publication of that. So there's all these different rights which can be owned by different people.
So when you want to approach Beyonce, Laura, I'll come to you and make sure that I've got my IP protected before I give her my wonderful voice.
Exactly. And the next case I'm going to talk to you guys all about is the Michael Hutchence case. So when Michael Hutchence died, you guys might be aware, it was ruled a suicide. So he died at the age of 38 in the Ritz-Carlton Hotel in Sydney. So he had a will, and he had appointed one of his trusted legal advisors, Colin Diamond, to be one of his executors, and I think he had another advisor as another option for being an executor. And he'd left a few bequests to two charities. So Greenpeace and Amnesty International were getting about $300,000 each. And then the rest was being split 50% going to his daughter, Tiger Lily, and 50% being divided between his wife at the time, who I think they were separated, Paula Yates, his mum, his dad, his brother, and his sister. So good job, had a will in place. Everyone thought that the estate would be worth about $10 to $50 million. So he obviously, like, lead singer of In Excess, famous and prolific, creator of amazing songs, and just, a real amazing artist. And it was really tragic what happened. So everyone thought, he's got so many different properties. He was supposed to have, Gold Coast properties worth about $10 million. He had a villa in France. He had a London house, Indonesian development that was underway. And everyone just assumed that there would be so much money there. But unfortunately, before he died, he'd assigned a lot of his rights to different companies and trusts overseas. So there was trusts from Liberia and to the British Virgin Islands, vesting the rights in his sound recordings, his images, his films, and in all of these companies and trusts to avoid taxes in some ways, but also for asset protection in case he went through a property settlement with a spouse. And he apparently wanted to avoid his family also sort of getting his money. So, but these trusts were set up with his lawyer, Colin. Colin was in charge of a lot of these trusts, and Michael was not a beneficiary. So he really trusted these advisors and said, let's put everything over here so it'll protect it all. But it meant that in the end, there was nothing left in his estate. There was a bank account with $500 in it. He got $500 from the In Excess bank account, which was due to his estate. And he had a few guitars and a Harley Davidson, which they sold for $2,000. And that was about it. So you can imagine there was some upset family members. So Patricia, who was mum, took Colin, the lawyer, to court, and a few of the other advisors that were sort of having rights over all these, offshore entities, took him to court and was successful in some way to recover some funds, but it was not enough to even cover the court costs of what they went through. So sometimes you think all of these assets are going to be in somebody's estate, and they're really not. So I found that a really interesting example of that situation. Poor Tiger Lily.
Yeah, and I wouldn't want to know what the cost was in getting lawyers to go after what's ostensibly a bit of cash and a few guitars.
Exactly. So under the Copyright Act, as I said before, copyright's a personal property which is transmissible by assignment, also by will, and by the operation of law. So when we talk about intestacy laws, then that's how copyright can be assigned in those ways. So sometimes there's a will and sometimes there's not. So when we make a will, we obviously have the right to appoint an executor and a beneficiary of these rights, so we have more control. And when there's no will, then the intestacy laws will apply in the jurisdiction in which the creator was living, or the copyright owner was living. And sometimes this does what the deceased would like with the assets, and sometimes, as we know, it goes awry. So the first thing that crops up is who's going to be the administrator of the assets, who is the most appropriate person who maybe shares the vision of the person who created the works to continue to commercialize and grow the reputation and legacy of those rights. So sometimes, obviously, when we're dealing with the administrator, it can be anyone entitled in distribution that can apply, and sometimes there's more than one person here. So maybe that person is the right person for the job, maybe they're not, and they need to get consent from everybody, and sometimes they can't get this consent. So this can be an issue. What was I going to say? So in WA, at least, sometimes where we have an estate worth over $500,000, and say someone's got a spouse and they don't have any children, but they've got their siblings, then the estate will be going, the first $500,000 to the $500,000 to the spouse, and then there'll be a third going. I think it's a half going to the spouse of the rest, and then the other half is split between the siblings. So sometimes that's what you want, and sometimes that's really not what you want. So a good recommendation is to have a will. An example here, you'll see this beautiful artwork in the picture here. It's actually something that I prepared as a paint and sip. But this example involves a Western Australian artist. This is fiction. So Pablo Hifaso was his name. He was a prolific artist. So he had many, many paintings. And he had a de facto partner who he was with for 30 years. Her name was Sheeta Barlow. They didn't have any children, but they had 2 standard poodles. So that were practically like their kids. They had James and Janice. So Pablo also had 3 really difficult siblings that he just didn't get along with. And as we know, we can't pick our family. So his estate was worth about $3.7 million, including his vast catalogue of paintings, which were artistic works under the Copyright Act. So what happened here on his death? Because he did not leave a will behind. So Sheeta got the first $705,000. Sorry, I said before it was $500,000, but it's $705,000. This is in WA. And she got half of the rest, being about $1.5 million. So she got a lot of the assets, but the other $1.5 million went between the 3 siblings. So that was not what Pablo wanted, and it's not what Sheeta wanted. And James and Janice, the standard poodles, they got nothing. It's very sad. And then the issues that arose here would be that no one could agree who was going to be the administrator to manage the estate and manage the copyright assets, and no one could agree who should actually own those copyright assets. So they then went to court and battled it out and spent a lot of the estate money. Believe it or not, Prince died without a will. So everyone knows Prince. He sang Raspberry Beret and many others. So Prince, they had to first of all find out, well, who's his next of kin, which took them ages. Found out that he had a sister and he had 5 half siblings. So they were then entitled in distribution to the estate. They had a court battle which lasted 6 years. So Prince, you could have just had a will and made things a lot easier, but he didn't want to for whatever reason. So he had a vast catalogue of music, and his estate was worth about $156 million. So in the end, they finally battled it out and worked out, okay, we've got these 6 beneficiaries who can equally share in the rights. But as you know, with joint ownership, everyone needs to agree, everyone needs to enter into an arrangement together to commercialise the rights. So in the end, they did, and 3 of them sold off their rights to a company, and 3 of them created their own company, and then they were the directors, and they, commercialized the rights with this other company. So
I think, Laura, if you need to take a break there, I think number one, you should have a second life as an artist based on that painting of yours, because that's pretty damn good. It's definitely better than anything I've ever done at a paint and sip, let me tell you.
I was quite proud.
Yeah, I absolutely think you should be proud. Also, definitely as a writer, because, Pablo Faso is just sheer comedy gold. So if anybody's interested about what you can do about your pets and your estate plan, then we do have a Facebook Live on that. Yeah, I just wanted to give you a breather and note how wonderful your artwork was. And I'm a very bad person with reading famous people cases. I only like reading the non-famous people ones. I don't know why that is, but I'm definitely getting a learning here about Prince. So.
Yeah, I actually really enjoy the famous people cases. It's so interesting.
Lots of people do, but yeah, I don't know why it is. I just like the everyday people ones.
So sometimes we're going to have a will, and that is the best option, but it's not always smooth sailing. As we said before, clients don't realise how important their copyright assets are, and that sometimes they need to be dealt with specifically, and most often they will. Yeah, oftentimes they're not referred to in the will, or they are, but in a way that can cause issues. So a few examples here. So the first one, I give my paintings to Sarah. Sounds pretty good. We've recognized what the asset is, but have we recognized the copyright in the asset or just the physical asset? So there's a difference between the paintings themselves and the copyright in the paintings. So does Sarah have the copyright? It's not clear. Without reference to the copyright as the specific asset, it simply falls into the residue of the estate, so the remainder. So in this second example, you'll see everything's been given real personal estate, whatever it is, and copyright's a personal asset. So it's been divided between my 5 kids, and if any of them don't survive me, then it's going to their kids. So then we've got the 5 kids jointly owning the copyright asset. And then again, that's creating those issues that can occur when not everyone agrees. Maybe not everyone's very savvy when it comes to those type of assets. They don't know, oh, we should definitely be dealing with this art gallery, and then we should be collecting royalties over here. So it just causes issues. This final example is where it's the difference between where we want to give rights to the beneficiaries, or sometimes we want to give rights, we want to give the income that's derived from the asset to the beneficiaries, but we actually want someone else to manage it for them. So in a will, you can actually appoint a specific executor to manage copyright assets. Maybe it's a musical executor, maybe it's a literary executor, so we can call it whatever we want to call it. And those people can have rights over administering those specific copyright assets. So when it comes time to getting probate for that, and I haven't actually seen this in practice, but I understand that I think you could do the probate application with having your general executor appointed over most of the other assets, and then you could have your specific executor appointed over those specific copyright assets. On that note, has anybody that's listening in dealt with that sort of thing coming up in terms of having a specific musical or literary executor appointed?
I think we'll give him a minute to generate in the questions, but I think this is a really good point, Laura, about, we should be considering some of these points around when, or how special that type of asset is and how many things you have to think about. I'm actually in the T2 Precedents Club hot seat after this. We are talking about specific gifts, and I've just quickly updated the slide because I've got a couple of hints and notes to consider when you're doing specific gifts. So I've updated that to include, are there any copyright things or special things to consider in relation to intellectual property? But if you have thought about that before and you want to share, please do so in the comments so we can come back to it.
Because maybe, in terms of who you would appoint as that specific executor, someone that's got the subject matter knowledge, maybe. So maybe it is your business manager, or maybe it's someone that worked with you at your architectural firm, something like that, to manage things. And you can still make sure that the benefits are all flowing back through to your family. But oftentimes our family doesn't have a clue. Sometimes they will, or there might be just one specific family member that, they would appreciate my vision for this. They really got it. But the others, not so much. So it just depends, and that's a really important thing to consider. There was a court case with Nicholas Enright. He was a famous Australian playwright, and he appointed one of his good friends, a writer called David, to be his literary executor. So the courts considered whether it was even possible to have this type of specific executor, and they said that there definitely was. So the ownership of the copyright that you can kind of ensure happens, there's varying sort of options. So you could send it to an individual, you could send it to a company, you could send it into a testamentary discretionary trust. We're all very au fait with those. That way you're putting in charge that person, that trustee, who might have the vision to exploit those rights, to license them. And then again, all the benefits can kind of flow through to the beneficiaries of that trust. That can be a really nice option for copyright. You could also be sending it to a fixed trust, for example, for a child who was a spendthrift or had a disability, for example. Joint ownership, as we know, brings up lots of issues, should be avoided if possible. Sometimes artists or creators want to send their rights to be used for an award, for a fund that can be used to give to, budding creators themselves, whether they be filmmakers or writers. So Miles Franklin did that in her will. In our will, we can have directions that are binding, as we are aware, and then directions that are non-binding and are mere wishes. So few examples here. So Adam Yauch, who's MCA from the Beastie Boys, in his will, when he died, he said, "I don't want any of my works to be used in relation to advertising." So he made that a direction, and I guess that the question of whether that's binding or not is still to be seen, because the rights are sort of co-owned with the other Beastie Boys. So it could be quite, restrictive. And it's an interesting kind of consideration when something's going to be binding or when it's just going to be a wish. Another example, Franz Kafka, who was a famous Czech author. So Franz Kafka actually had so many works that he hadn't published when he died. And one of his best friends was a fellow called Max Brod. And he left everything to Max, and he left with his will. So in his will, Max is the executor, Max gets everything, but he had a letter of wishes which sat alongside his will, which said, "Mate, can you please just burn everything? I don't want anything left of mine. That was, my notebooks, my manuscripts, my letters, everything else, just burn them. And if anyone else has a copy, please just burn it." So he obviously didn't really enjoy what he'd done. Or maybe, I don't know, maybe he just didn't want to share it with the world. So Max, you go.
That's really interesting, Laura. Yeah, because I know there's, hear me saying that I don't get excited about the famous people stuff, but I know there's a few authors who, their family member or someone close to them have gone on to kind of complete the work. Like, I think it was Robert Galbraith who did the Wheel of Time series. I think is that the right author? And I think his son went and ended up finishing that. I mean, I don't know when that series is ever going to end, to be honest, but maybe that's a point, not wanting it to be kind of someone else later on. So that's a very interesting consideration around when you're dealing with people with art about whether they want someone to go and finish their work off.
Totally. And so Max saw the vision in Franz's work, saw the beauty of what his friend had created, and he fled Nazi-occupied Prague with a suitcase full of all of Franz's things, and he published a lot of it against his friend's wishes. And that's the reason why Franz is so well known globally now and so well respected as a writer. And then Max then later died, and he left all of those rights to the Israeli National Library, because he wanted it to be, displayed. He wanted it to be honoured by this institution. And there was a few papers and things, and he'd left with his secretary. And his secretary was like, yep, no worries, Max, I'll do that for you. But what do you think she did? She decided to sell off some things in an auction online, made millions of dollars of ill-gotten gains, and the rest of it just sat around her house. And it kind of went into disarray. Her cats got amongst it, destroyed some works, as cats like to do. And then there had to be a big court battle with the Israeli National Library saying, "Can you please give this back to us? This is rightfully ours in accordance with this will." And that only just settled earlier this year, and Franz died in 1924. So, the journey of his works has really, it's come a long way.
Yeah, that's I keep thinking George R.R. Martin's going to die before he finishes anything. So I keep wondering who's going to finish his stuff. It's almost heartbreaking a little bit that, you know, his wishes didn't necessarily permanently come to pass because that's what he wanted, you know. So important to make sure your wishes end up in the hands of the right people.
Yeah, and I suppose, and putting it in the will, maybe. I don't know. Has anyone dealt with the direction to destroy works in a will? It's an interesting one. So moving along though, as as time's running along, so we've got a difference between what the executor can do and what the beneficiary can do. So an executor has a lot of duties, one of them being a fiduciary duty to act in the best interests of all of the beneficiaries. They want to make sure they're avoiding any conflicts. They don't want to be seen to be, you know, saying, oh, yes, we'll do whatever you want, Sarah, but not acting in the best interests of the other beneficiaries. They need to be able to call in all the assets, realise and maximise the value of those assets. And so that comes in, it's really important here when we have these types of assets, these copyright assets, that they know what they are and that they have some sort of clue about them. They have to exercise the care and skill of an ordinary, prudent business person. In some situations, and in a lot of wills, you will see the right for the executor to deal in the assets of the estate as if they were the owner. So they can sell off an asset, change investments willy-nilly, assuming there's nothing else in the will to tell them otherwise. So in Michael Jackson's estate, so he left a will, which you can find online if you Google, which is great. It's always nice to see what famous people do in their wills. So he sent off everything shared between, sent to a family trust, of which the beneficiaries were his mum and his 3 children. Who were they? What were their names again? I think it was like Paris, Blanket, and... Where's my notes?
I'm so bad at famous people things that there's no chance of ever remembering anybody's name. I can barely remember my own, Laura. So
Prince, Paris, and Blanket. So his estate was actually in debt, $500 million US. Yeah. So what the executors did, now the executors were his trusted advisors. So we had John McCain, and John Branca, who was a music executive, and they were all, you know, MJ's close friends and trusted advisors. So what they did is they sold off some rights that were in his estate. He had a huge stake in a Sony music catalogue, which held some of the rights to the Beatles songs. So there's this like amazing catalogue of musical works. So they sold them off to Sony for $750 million US. So we're bringing the estate out of debt, which is something that the executor has to do, pay off any debts before they distribute. And then they were able to transfer the sort of the cash proceeds into this family trust in accordance with the will. Mum didn't like it. Mum thought we should have held off and sold later because she was like, you could have got a better deal than this. If we just held off and you should, and under the will, you were supposed to transfer all the assets into the trust. But actually the will never said that. The will just said, I give my estate to this trust. So, and there was actually an express power for the executor to sell any assets if they wanted to. So that meant that the courts was like, no, they did the right thing. They were calling in the assets. They were maximizing the value. They were paying off the dets.
Where were these trusted advisors when you were spending $500 million is what I want to know. Where were they then?
I know. It's crazy.
There's lots of financial planners in this group. I hope, if I was doing this, you guys would all be on to me about it. So, yeah, but I understand the mother, especially when it comes to stuff that you can never really get back like that. But what choice did they have, really?
Totally. And I think a lot of the debt sometimes comes from not paying tax. So I think a lot of artists try to avoid tax, and then it comes to roost. So, yes. A more recent case and more close to home. So this was the case of Vaughan. so Henry Vaughan in particular, in Victoria. So he was an inventor, a robotics inventor. So he left behind, he did leave behind a will, but everyone he had appointed didn't want to act. And he had two stepsons, James and Simon. So James worked in the business and Henry applied to be the administrator. So he applied to be the administrator with the will annexed, and he was appointed in that role. So he did not appreciate the, the copyright assets in his stepdad's estate. So Henry had a factory which contained plenty of sensitive material. He had a robotic system, business records, engineering drawings, manufacturing drawings, and designs relating to the robotic inventions. He had a computer system and software used to operate the robot and associated machinery. So in my mind, all of these things would raise flags like, is there some intellectual property here? He's an inventor, for goodness sakes. So Simon, as the administrator, took steps to organise an auction of all of the items in the factory, but he didn't include any intellectual property in this auction, even after his brother had said, hey, I really think you're missing something here. I really think you need to think about the IP. He just ignored it. So he sold off everything for about $20,000, and he chose to dispose of a lot of documents which he considered valueless or in a state of disrepair. So he was like, look, I've done a search of the IP registers and I didn't find anything in my stepdad's name. But with copyright, you see, you don't have to register it. It exists upon expression. So in Australia, there's no registration system. You can't search to find, the owner of a particular asset. Different to America, where we do have a registration process there. So then James took his brother to court and said, hey, you're not doing the right thing here, and you should step down as administrator. So you failed to consider, identify, and value the IP, and you haven't called in all the assets of the estate. So the court, in this case, found that intellectual property definitely did exist, and that Simon should have known that there would have been IP in the factory, and he should have known that there could have been value in this IP, in this copyright, in all of the robotic drawings, software, etc. They valued the IP at around $300,000. And the court said, look, Simon breached his fiduciary duty as the administrator of the estate by not valuing this and not realising this for the beneficiaries. So Simon was made to pay, it was $300,000 plus interest to $420,000 personally. So he was personally liable as administrator, and he was then removed. So this case teaches us that as executors, we have these rights, or you might be advising your client who's an executor to realise the assets of the estate and to maximise the value there. And if you don't, you could be held personally liable for it. A few other considerations as executor will be around are there any contracts on force that need to be followed? Once someone dies, there might be a license agreement in place that needs to be respected. You'll see, where did I put it here? So a license under the Copyright Act will bind every successor in title. So the new beneficiary will still be bound by that license. So really important to know what licenses are in place. Need to think about whether there's any collecting agencies involved. And in this regard, where is it? Here we go. There's a bunch of different collecting societies in Australia that collect royalties for copyright works, depending on what they are. So the Copyright Agency collects royalties for literary works and for visual or artistic works. APRA AMCOS are involved with performance rights and mechanical copyrights with respect to music. So performance rights being the right to perform or have the music heard in a public space. And then the mechanical rights are the rights associated with the recording itself. So they're kind of often linked with one another. So this organisation you can register with, and then they do all your dirty work for you in terms of ensuring that every time your music is played or your rights are used by someone else, that the royalty will come through to you as the beneficiary. So if these collecting societies are involved, as executor, you might want to look into that, and you probably need to let them know, look, this person's passed away, and these are how the rights have been distributed. These are how they're given. So showing them a copy of the will. Sometimes they'll require a grant of probate. I spoke to a fellow at APRA AMCOS here in WA who said that in most wills he sees that these rights are not specifically referenced. So oftentimes they're falling into the residue of the estate. And so they're having to sort of work out, all right, there's these three beneficiaries who are due to inherit this, and the royalties should then go through to them or through to the executor who will manage that for them. If you're an artist who has visual works, there's a federal legislation called the Royalty Resale Rights legislation, and this allows for the second sale of your work to bring back 5% royalties to the original artist or their estate. So this came about because oftentimes, particularly with Indigenous authors, they were selling their works off very cheaply for the first time, and then the second or third sale of that work will be streaming in sometimes millions of dollars. Maybe it's going overseas and receiving so much money, but that original artist wasn't receiving the benefit of that, even though that was their work, their copyright. So this work is in place, means that for every second commercial sale of the visual art, which is for at least $1,000, we got 5% of the proceeds coming back to the artist or their estate. And this will keep happening for every sale for the life of the artist plus 70 years. So the Copyright Agency Limited, which is one of those collecting societies, they often will collect these royalties for the author or for the estate. So really important if you're the executor to be aware of this if it's relevant, so that you can be collecting these royalties and bringing them back to the beneficiaries. One other thing before I summarise here is a question of whether the executor will need to perfect the chain of title to the ultimate beneficiary by doing an assignment of rights. So as we know, all of the assets of an estate will sort of vest in the executor or administrator when someone dies. So, and that happens once we've got that grant of probate or the letters of administration. So, and then the executor's job is to obviously pay off all the debts and testamentary expenses first. So the copyright assets may not ultimately vest in the ultimate beneficiary if there's not enough money to go around, and maybe those copyright assets need to be sold off, as they did in Michael Jackson's case. So sometimes it's not going to go straight to that beneficiary. So I think, and I've spoken to another practitioner in this space, Therese, who agrees that there should be a assignment in writing from the executor on behalf of the deceased to the ultimate beneficiary to perfect that title and to prove that ownership of that right. So a few little takeaways for you and for your clients. Thinking about making sure that you make a will, making sure that you pick the right person to be your executor or your trustee, who's going to have the vision, share the vision of the testator, who's going to be able to commercialise those rights. Really good idea to have a register of what those assets are. What copyright assets are we talking about? We can specifically mention some in the will, but they can sometimes change over time. So great idea to have that updated by the client to say, you know, the list of the musical recordings or the artworks or the, you know, we've got these manuals, we've got these engineering drawings, etc. It's a bit of a job. A good idea also to sometimes leave directions for digital assets. So if you have for example, a non-fungible token, which is a whole nother topic. How are we going to access these digital assets? I think it's just a really good idea to also value the assets if possible, or have an understanding of why they might be important in that person's estate.
Thanks so much, Laura. I've got a couple of questions come through. So someone asked about NFTs, and I think that, as you said, that you could probably base a whole entire training on those in particular. But for anybody that wants to talk about digital assets, we do have a training with, I think it was Kimberly, who's our digital person. So recommending having a look at that. I think there's a few questions around some of that AI space and source code, those sorts of things. I think given the time we have, I don't know if it's something we can cover off fairly. So I might park that AI question, and it's something that if you're in our TT Precedents Club, please come in, have a chat with us about it, because I think that would be very interesting. Laura is a long-term lover of our TT Precedents Club, so she might be in there one day, and feel free to share her thoughts on AI and how we or who owns the end product. Couple of very practical questions here. So Tara's asked a tax question, which I always find funny because Tara is the tax guru out of certainly this one and me and her. But she sort of said, if there's intellectual property created after the introduction of CGT in 1985, obviously, will it have a $0 cost base when it's inherited under a will? So I think that's an interesting discussion, and certainly if you're a tax person and you're listening, please type your comments in so that we can hear you. Tara, that means type your own answer in.
I'm not sure.
And then we had Taylor mentioning about having the two different executors, and I think she said she looked into it, and yes, when you do get a grant, that both executors are noted with their scope being limited to the actual terms of their appointment under the will. What I probably thought was a really practical point to give people a bit of a takeaway to think about is, obviously, estate planning is getting a lot more complex, and therefore estate administration as well. But often we have people that have kind of assets everywhere. That Michael Hutchins case is a really terrible outcome answer of that happening. But given that copyright is probably very similar to property, that it's very specific to the jurisdiction, if someone does have copyright interests around the world, is your recommendation similar to what our general view is, that you should have an estate plan for each of those jurisdictions?
So copyright interests around the world, so what they created the copyright in different...
I just know that, like, the concept of when copyright is created is different between, say, for example, Australia and America, right?
Yeah.
So
agree. So if they were commercializing their rights overseas in different jurisdictions, then yes, I think they should have wills in the different jurisdictions.
Yeah, because I know that we have some agreements that are generally supposed to respect international kind of rights in relation to those sorts of things, but practically when we play them out in the estate administration phase, it can be a lot more difficult if you don't have advice on how some of those systems work. So
I would do that.
Last question I have here, and Denise might have to clarify this a bit for me. She's talking about, what about when things are held in escrow?
So until something happens, they have to, someone's holding it on trust for them? Is that?
I'm assuming so, yeah. I think, Denise, we might need you to give us a bit more detail around that, but I suppose it depends on what you're holding.
On the sale of a business, maybe? Is it on the sale of a business? Is that what she means? I don't know.
Yeah, I'm not sure, but maybe, Denise, if we can feel free to reach out to Laura if you've got any specific issues that you want to talk about there. But I think the point is that it is so very specific to the particular asset type the particular event happening and where that is owned, and not necessarily just the asset type too, but the way that asset type is treated under the relevant law.
Yeah, feel free to reach out to me. I've got my contact details on the screen there. So I'm at Tatchell Legal over here in WA. And if you ever have any questions that crop up, or if you have clients that need support in this space, or the WA clients that need somebody, I'm more than happy to help.
Excellent. Thank you so much, Laura, for sharing your information with us. I think it's really important that we understand those when we're doing our estate planning, and we do have obviously some estate admin people in the group as well. So feel free to reach out to us, feel free to reach out to Laura. Otherwise, we will let you all go off and have a really great weekend. Thank you so much for your time. Looking forward to seeing you all next month.
Thanks, Carrie.